On 3FM 92.7. Let's head back to Parliament.
My friend Abraham, I'm about
Sir Justice Dennis J was one of the nominees sent down to go to the Supreme Court. President John Dramani Mahama.
Only I find one person.
His vetting was enjoyed by many.
I shall spare them.
But just so you know, the Black Rasta, Rootica, the Artica, he will be on your radio at 1 p.m. Guess what? It was Fosti that gave me that privileged information. One Mamia. Black Rasta Mamia. Hey!
In the context of separation of powers, to ever place the head of the judiciary as the head of the executive.
No, please. Because we had one in 1957 which brought about problems. Whenever there was a bad law, like PDA, deportation order, the Governor General, Lord Listowel, will travel to England, and the Chief Justice will sign to make him unpopular. So it is not advisable to use the Chief Justice as one of the to exercise one of the executive powers. It is not advisable. Thank you.
Because within the context of separation of powers, if the person who is the arbiter becomes the actor, how do we resolve misconduct by that person or wrongful conduct by that person that gets contested in your court?
Thank you. Thank you, Honorable. It could be a bad practice, because why do you involve a judge or chief justice whose role is resolution of disputes? Executive. If it extends to Parliament, there's nothing wrong, because they are politicians. They were voted for. They put up their campaign, and at the end of the day, they were voted for. So they can act. But where the Chief Justice, you are supposed to be independent, impartial, and you are to go and perform executive function, it will violate every principle of rule of law. Thank you.
Of the history, only for language, yet one
3FM Sunrise.
No for religion, yet one people. Sometimes we cuss, also we fuss.
Does not bind any court, because that was not the issue before the court. So my simple understanding is that it is to give legitimacy and to end the cap. So the cap has been fixed, the three. Because why do you go? So in that sense, you also go to say that in the absence of the Chief Justice, then in the absence of that person, in the absence of that person, then what is the essence of providing for leadership in your country? That is the essence. Thank you.
Thank you very much.
Thank you.
Any follow-up?
That's right. Yes, because so by your interpretation, what if by necessity, and there is a Latin maxim that says that necessitatis non habet legem. By necessity, we don't have the president in the jurisdiction. Maybe the vice president has been taken ill, and then the speaker obviously had to be out of the jurisdiction. There can't be a vacuum. Somebody necessarily has to step in.
Well, I will allow the supplementary question subject to the aspect that says the vice president is ill, because the Constitution used the expression absent from the jurisdiction. So, my Lord, you may proceed to answer the question.
Thank you, Mr. Speaker.
Thank you. You know, there have been two Supreme Court decisions on what do we mean by absence of the president, vice president, or the speaker. And it is the interpretation that has been given. And to me, that interpretation to me, contrary to purposive interpretation. Because we must look at the purpose for which the law was made. And why do we talk about purposive interpretation? Purposive interpretation means we look at the purpose, and the purpose is determined by time, circumstances, and development. The things that we had 20, 30 years ago, they are not the same as now. So I believe if in future that there should be a decision, the time and the circumstances may change the decision that the Supreme Court may render. It is possible. And we are saying that the Constitution is a living organism capable of growth. And the Constitution can grow at any time. The meaning can change depending on time, circumstances, and development. Thank you.
I will then give the floor to Honorable.
Last follow-up. Last follow-up. Mr. Chairman, aren't you enjoying the discourse?
You have exhausted your limit. The majority leader wants a follow-up.
Yeah, but Justice Dennis, if you look at the provisions of Article 60, they clearly anticipate, and I do agree with you, that if the president is not there, the vice president is not there, the speaker. If all of them are not there, the vice president and the president are not there for a given period, the assumption is that, let's say if they are not there and will not come back, if they will not come back, then there must be an election in 3 months and a new president will have to take over. So clearly the Constitution is firm on the people who can occupy the position of president or acting president and for what duration they can act as president. So what would have necessitated an arbiter to the effect that Chief Justice can act as a president? What, on the basis of which provisions did that come up?
Thank you. It was by Professor Kruje in the case of Asarabes Attorney General, which I personally, even though it is an arbiter, I disagree. Because if you are interpreting, you must interpret within the context, and you must be fair. You must be fair to the text. Faithfulness, that is cardinal principle in interpretation, faithfulness to the text. Where it has not been stated anywhere, but I do not blame him because he was discussing the position of the law between 1957 and 1960, where in the absence of the Governor General, all the bills were signed into law by the Chief Justice. That was the position then. So he used that one because that regime, the order in council 1957 is different from 1992 Constitution. So at no point in time can you compare the two. So if you look at it, he was influenced by that position, but within the context of the Constitution, it cannot be so. Thank you.
Is it desirable in the context of separation of powers to ever place the head of the judiciary as the head of the executive?
No, please, because we had one in 1957 which brought about problems. Whenever there was a bad law, like PDA, deportation order, the Governor General, Lord Listowel, will travel to England, and the Chief Justice was signed to make him unpopular. So it is not advisable to use the Chief Justice as one of the to exercise one of the executive powers. It is not advisable. Thank you.
Because within the context of separation of powers, if the person who is the arbiter becomes the actor, how do we resolve misconduct by that person or wrongful conduct by that person that gets contested in your court?
Thank you. Thank you, Honorable. It could be a bad practice, because why do you involve a judge or Chief Justice whose role is resolution of disputes, which is different from the role of the executive? If it extends to Parliament, there's nothing wrong because they are politicians. They were voted for. they put up their campaign, and at the end of the day, they were voted for. So they can act. But where the Chief Justice, you are supposed to be independent, impartial, and you are to go and perform executive function, it will violate every principle of rule of law. Thank you.
Now, looking at, I think you, from your previous answers, you seem to me as a judge who has some belief in the purposive approach to constitutional interpretation.
I have several publications on it. Thank you.
So you endorse purposive interpretation?
But leader, do I take it that you are now having your turn?
Yes, I'm having my turn.
Very well.
You endorse the purposive approach to constitutional interpretation?
That is so.
Now, Article 60 talks about two scenarios: absence from the country and inability to perform your functions. From a purposive approach to interpretation, in this era where absence from the country is not the same as inability to perform your functions, in view of developments in telecommunications and etc., where you can even sit abroad and then chair a cabinet meeting, where you can sit abroad and receive briefings. In fact, on your aircraft, you can actually chair a cabinet meeting taking place in the Flagstaff House. So on a purposive interpretation to our Constitution, given that the Constitution is anticipating absence from Ghana based on an assumption in 1992 that when you are physically absent, you will not be able to exercise your function as president, or where you are actually here but you are unable to perform, maybe due to ill health or some other consideration. Given that that is not really something that practically exists now, can we say that at any moment a president is absent from Ghana and as a result unable to perform his functions, by which reason, when both president and vice president are not there, there is a fundamental breach of the Constitution?
Thank you, Chair. When we talk about unable to perform his function, and it is outside or he's outside the jurisdiction, and if you look at the decisions rendered by the Supreme Court, the one against Honorable Do Ajaho, the Supreme Court said that no, the person must be physically present in Ghana. That was the intention at the time the law was made, because we were scared of soldiers, that the least the soldiers will come, and therefore, as a commander-in-chief, if you are not there, somebody should take over from you. And as I said, when we take into account purposive interpretation, what we do is that we look at the law. We look at having looked at the law, then the next thing that we do is we look at the context within which it was made, context. So having taken it out of the context, then we move to the second stage. We look at the purpose, the subject matter, the scope, and to some extent the background. What informed that? The background, does it still prevail? So I believe if there is a new application, nothing will prevent the Supreme Court may take into account technology, development, and move to different level. Nothing may prevent it, because if it is to be construed purposively, then whether the president is in Ghana or not, provided he's not sick, he's not seriously sick and can perform his function, I don't think this should be a critical issue.
The best in the morning is on 92.7 Sunrise on 3FM.
And those were excerpts. Said in as a J. His Lordship said in as a J. Appeal Court judge now hopefully to be elevated to the point of Supreme Court being on the Supreme Court bench. Very interesting 13 motions there. We'll go back to Parliament and then get also excerpts of vetting of His Lordship Chairman first.
True judicial independence requires constitutional courage. Deciding cases on law and precedent not political preferences. It means protecting minority rights against majoritarian excesses. It means sometimes disappointing those who appointed you because the Constitution demands nothing less. This committee bears solemn responsibility for ensuring only nominees demonstrating unbending commitment to judicial independence receiving approval. We must probe not merely legal knowledge, but constitutional philosophy and commitment to deciding cases without political consideration. To all participants, embrace robust discourse with dignity, ask hard questions, challenge respectfully. Our democratic maturity is measured by our ability to disagree with purpose while maintaining civility. To Ghanaians watching, witness democracy in action. Tolerate provocative questions. They are democracy's oxygen. We are building a nation, not trading insults. To the media and parliament staff, thank you for enabling this democratic exercise to be undertaken. I conclude by saying that we stand at a constitutional crossroads. These proceedings will either restore judicial confidence or mark the day Ghana's highest court become an executive instrument, not constitutional conscience. The nominees seek sacred constitutional trust. May they prove worthy. May we test that worthiness thoroughly. History will judge whether we defended democracy when it needed us most. Future generations will thank us for courage or condemn us for cowardice. The choice is yours. The time is now. Thank you, Honorable Chairman.
The best in the morning is on 92.7.
Thank you very much,
Sunrise
Chairman.
on 3 FM.
And thank you for indulging me. I did not know the minority leader had a scripted statement as he has done. So I don't have a scripted response, except I picked on a few things that he has said. One, he speaks about the ongoing process relating to the Chief Justice, Justice Gertrude Tokono. I first and foremost think that this is not the proper platform to be questioning the processes involved in relation to Justice Tokono. I think it is inappropriate, but let me just indicate that there is nothing procedurally questionable in terms of the processes that Justice Tokono is being taken through, because the Constitution is clear in terms of what the process is, and that process has been followed diligently, and efforts to question that process in the Supreme Court has not been successful. And so I find it inappropriate that before a committee of this nature, the minority leader will be questioning the process. And on the issue of accusation that this government is engaged in double standards, I think that is also not appropriate. The nominees are before you for you to vet their suitability, and to say that this government is engaged in double standards is totally inappropriate. I was on the appointments committee when the two nominees were rejected, and let me indicate clearly that my side of the house advocated for the rejection on the basis that at that time the anticipated retirement of some judges, which would have created the vacancy, hadn't taken place, and there was no need in anticipation to be appointing replacements. And we also argued, and I do not shy away from that argument, that the then president had had the opportunity to nominate so many members onto the Supreme Court, and even if some judges were retiring, he should give the opportunity for an incoming president, given that we're so close to elections, to also have an opportunity to also nominate people to the Supreme Court. It wasn't clear who will be the incoming president. It could have been an NPP incoming president. It could have also been an NDC incoming president. That basically was the crux of our argument at that time. And so for someone to today be accusing this government of double standards, in my opinion, is inappropriate. And I think that we should not use the nomination of these Supreme Court judges as a the vetting of the nominees as a platform to be engaged in partisan politics. I think that basically that will be my response for now, and I welcome the nominees, and as indicated, we will be vetting them according to the standards set by our Constitution, and I hope that this doesn't become another partisan bickering exercise. Thank you.
The best in the morning is on 92.7 Sunrise on 3 FM.
Your colleagues who came before you, especially during Kufuor's era, had cause to give a certain interpretation to the Constitution. And just for our purpose, I remember that in looking at the law, they suggested, they made a strong point in their judgment to the fact that once the president is out of the jurisdiction, there must be someone in the jurisdiction to act, and the person must take the judicial oath. Now, it's been long. This ruling or judgment has been in our books for so long a time. It's like what we previously, as lawyers, were adhering to, that when an injunction application is filed, though it has not been determined, once you've been served, you must not do anything to disturb it. And we're going on with this for a long time, till recently in the Purposive 3-2 decision, my Lord Kulendi, writing the majority opinion, said no, there must be express order from the courts. That is now the new law without any ambiguity, and says that constitutional bodies must be allowed to do their work and all. The nation has heard you, the court on this, and we would abide. Now, having given you this sufficient background as to precedent, may I know from you whether, in view of technological impacts on the practice, and you've talked about AI this morning, on repeated occasions, in view of technological impact, having regard to Article 68, would there be a requirement for the Speaker to take presidential oath when acting in the absence of the President and the Vice President?
Mr. Chairman, if the law says he needs to take an oath, he has to take it. If he doesn't say so, then he doesn't take it. Thank you.
But does the law say so? The Constitution says so, that he must take an oath when acting as president. Take the presidential oath. Does the Constitution say so?
Yes.
Lord may guide us with the particular exact provision, please.
If you see, I think it's
The best in the morning is on 92.7 Sunrise on 3 FM.
Well, I can't get it offhand, but Mr. Chairman,
we can look at it. You can take your time and provide that later. But you can furnish us with that later. But my Lord, my question directly related to this is that in an era of instant global communication, does this distinction remain constitutionally necessary, and should, quote, absence from the Republic, unquote, be redefined in your view?
Mr. Chairman, with technology now, absence it has a different meaning now because a case came before me as to the meaning of working from home, as to whether during the COVID time, working from home, whether it's from your house or from outside the workplace. I think if the president, this is my opinion, please, if the president should be out of the country, let's say for 1 day, and coming back, yes, the constitution says there should be no vacuum. But if the person if the technology can make you work from outside your office, but well, the law says if you are out of the jurisdiction, fine. But if you are in contact with those who you work with, I don't really think, and the period is that short, maybe 1 day, I don't think there should be this ceremony when you are coming back the following day for somebody to swear an oath, and then the following morning, the president or whoever's oath is taken is back.
Is my law departing from the law? Is the law?
The law is the law, but I'm not departing from it. But what I'm saying, this is my personal position. Mr. Chairman, what I'm saying is that, let's say the president goes to Nigeria and will come back in the evening. He's not in the country. But that does not necessarily mean that the vice should take an oath to act for him when he's coming back in the evening. I mean...
The best in the morning is on 92.7 Sunrise on 3 FM. The best in the morning.
Say congratulations, well done.
Thank you.
I looked through your CV and I realized that you are a basket of a lot of knowledge and good things in your own industry.
Thank you.
We have observed that in our justice system and justice delivery, many a times, a lot of your work is delayed. A lot of your work is delayed. Someone could be in court for even 10 years. Not even only, not in your place, the superior, but even the lower courts. So there is this perception that justice delayed is justice denied. What is your view on that perception? And what will you suggest to be done to stop or at least to reduce the delayance in justice delivery? Thank you.
Thank you, Mr. Chairman. Some few minutes ago I said we have to look at the tools we use. We have to go high technology now, AI. One of our main constraints is the recording process, writing longhand, and then the processes by themselves. A lot of people who don't know this always say cases delay unnecessarily. Yes, sometimes it does, but then the procedures we have to see to it that we shorten the procedures and the time limits. Then secondly, I talk about the tools. If we can go AI, said that recordings are done swiftly, so that by the end of the day, whatever everybody says in court is recorded by the machine, and at the end of the day, it's transcribed, and you can just sign. It makes it faster. And then number two, a lot of adjournments. That one depends on the courts. A lot of lawyers come, I'm sick, I'm that, sending letters and blah, blah. We have to curtail those things as well to make sure that cases go on. And then I said something earlier that there should be time limits. I think the rules of court should set time limits, that no criminal case should go beyond 3 months. No civil case should go beyond a certain period of time. Then we all know we are constrained to finish within that time. These are the things we have to do to be able to quicken cases, to fasten the delivery of justice. And then more courts. If we have more courts, then the workload is lessened. One court wouldn't have plenty cases if there are other courts around. So, Madam, these are some of the things we have to do to be able to deliver justice in good time. In good time. Thank you.
Chairman.
Any further question?
Yes, please.
Please do.
something of very big interest. If you go to our prisons, most of them are choked. And it's as a matter of judgments, either delayed or wrong judgments or whatsoever. My main worry about those in these prisons are that some of them are not persons whom we should even send to prison, or we should even delay their cases. Someone goes to steal a bunch of plantain. An underage goes to steal some rice in a cooker and is eating. All these people, you collect them, you go and dump them, and sometimes even they are not segregated. The hardened, the non-hardened, all of them are together. What will you suggest to ensure that I will call these people, these little pilfering and what have you, they don't find themselves languishing, sometimes even years, sometimes forgotten, either in being called that they are in detention or they are whatsoever.
So, Honorable Hajaladi, what is the question?
My question is, what will you suggest to be done to those people so that we don't get them going into detention and wasting time?
Thank you. You said we collect them and go and dump them. We don't do that. We we try them, and if they are found guilty, they are convicted and sentenced.
Please, I'm not referring to the convicted ones. I'm referring to those that, for instance, you just say, oh, you have to go and come every day, go and come, and the place is choked. When the police cells are full, you remand. You send them to the prisons where maybe they are not even supposed to go. They are the ones I'm referring to, but not the convicted ones.
Thank you, Madam. We as judges interpret the law, the laws you make. If you change the laws, we interpret it accordingly. The prosecutors come to ask for remand because they have not finished with investigations. Madam, you can't ask the people to go home. You remand. But like you are saying, of course, it must be reasonable time. So until the laws are changed, there's nothing the judges can do, please. Thank you. So we are waiting for you to change the laws. Then, for example, the penal system, we are looking up to you. If you change it, fine. Thank you.
Yes.
I think I'm done.
Very well. I'll proceed to give the floor to the Deputy Ranking, Honorable Patricia Apiaje.
Right, thank you very much, Mr. Chair. Honorable nominee, going by your CV, I'd like to ask a question, because if I look at the time that you were born and the time that you entered secondary school, I'd like to find out, at what age did you enter the secondary school?
A little less than 12.
Specifically?
I went to the secondary school in 1970.
Yeah. So we presume that you entered at the age of 11.
11 plus amends, please.
Thank you very much. I found it very interesting because at that time we had people entering secondary school at the age of 13 and 8. So I found it very interesting.
Luckily, my father was a head teacher, so I went to school.
Right, thank you. Honorable nominee, how many judges do we have at the Supreme Court currently, practicing judges, and how many are women? I'm talking about current one. How many are women?
Currently, we have two Justice Avril and Justice Mensah Bonso. And then the CJ Justice Tokono, 3.
And how many in total, please?
13.
13. Thank you. Honorable nominee, I'll proceed to bring to your attention that last year, 2024, exactly in June, the Gender Equality Act, Act 1121, was passed. One of the questions I want to put to you at this point in time is that this act mandates gender parity in public appointments. And Article 144 requires merit-based judicial selection. If these provisions conflict, for example, if achieving gender parity requires appointing a less qualified candidate, which takes constitutional precedence and why? Which of the two? I've given you indication of the constitutional and then the legal aspect of it. Thank you.
Mr. Chairman, as much as possible, you should send the best to the Supreme Court, or you should appoint the best wherever. You don't use the gender equality thing to appoint somebody who you think is not qualified, but because of gender. So I will always go for the quality. If it means one person who is qualified, fine, go for that person. Don't say because of gender. If the person is not suitable or qualified for the job, you appoint the person to satisfy gender equality or gender parity. Thank you.
Thank you very much. So, to follow up, I would like to find out, what would you suggest should be the best approach in ensuring the achievement of the gender parity as it exists in the law? Thank you.
Mr. Chairman, if a lady qualifies, or yes, if a lady qualifies for a position, why not? Gender parity does not necessarily mean that you appoint women to satisfy the numbers. No. If the woman is qualified equally as the man, then when you are appointing, you look at that. You don't give the chances to men as against women. But that does not mean that you push ladies who are not qualified for the job to satisfy that parity. Thank you.
So, Chairman, I think I need clarity on this because I asked a specific question. What would you recommend should be the approach to achieve that? Thank you.
Madam Chairman, if you pass me through and I get to the Supreme Court, then maybe when it comes, I can then recommend, but as at now, I cannot recommend anything. Thank you.
Any further question?
Yes. Thank you very much. Honorable nominee, one of the issues are constitutional interpretational issues that we have faced. In the 1992 Constitution, it guarantees equality before the law and prohibits discrimination, as you rightly said. Given that approximately about 35% of Ghanaian couples cohabitate, how would you reconcile the constitutional principle of equal protection with the current legal framework that denies cohabitants the same rights as married couples? Should the Constitution's equality provisions extend to protecting cohabitants from legal vulnerability?
Mr. Chairman, as at now, what the Constitution says is what we have to do, because whatever we say beyond the Constitution is noise. And no matter how many noises you make, What the Constitution says is what overrides. Thank you.
The best in the morning is on 92.7 Sunrise on 3 FM.
Those are some views from the vetting table in Parliament. Very interesting thoughts, aren't it? Let me give you a chance and hand over the microphone to you to tell me what do you think of our nominees. 055-924-2717, 055-691-0154. Some very interesting thoughts though that were shared around the table as well. Includes the viewpoints on tribunals and why we should have those tribunals. And for example, I take the views of Justice Jamafe on this one. He says that bring your mind. Says in adjudicating cases on tribunals, the law is 20%, while wisdom is 80%. The wisdom of the two ordinary members on tribunals must not be taken lightly. They can't be bullied. Justice Jamafe also maintains that one of our main constraints in the manual process in case management, if we use AI, for example, recordings can be done swiftly. He also holds the view that the Constitution says all public officers must declare their assets. Supreme Court judges must comply. This I found quite interesting. That if the Constitution says all public officers must declare their assets, Supreme Court judges must comply. He says he has declared his assets. We'll be asking all the other judges to also declare the assets if they haven't done that already. Justice Dennis Dominic J says, if you cannot marry at 16, don't have sex. Let's set the legal age for marriage at 18 years. Justice Dennis J also comes out to say, it's not advisable to use the Chief Justice to exercise one of the executive powers. These days, anyone who goes to court and loses things, it's because they didn't pay bribe. But that's not true. Most of the time, it's simply because the case is bad. Said Justice Dennis J. Don't remember being offered a bribe and by anybody. Will never take any. It's against my upbringing. Justice Gabriel Subare. Very interesting thoughts there. Let me ask you, should judges also declare the assets? What do you think? 055-924-2717, 055-691-0154, 055-924-2717, 055-691-0154. Good morning.
Hello.
Yes, good morning.
Yeah, good morning, sir.
Yes, boss.
Please, am I speaking to Johnny's bike?
You are speaking to Johnny Hughes.
Okay, thank you very much. Please, I am speaking from Manya Krobo Senior High School.
Okay.
Yes, I'm a teacher over here.
You want to talk about the judges?
No, not teacher issue, but this is a visa fraud issue that I want to report to.
That's a police matter. Sorry about that. Good morning.
Good morning, Nimpaku Hughes.
Yes, sir. Uriel, how are you doing?
God has been faithful. I'm doing very well.
Sir.
How are you?
Yes, sir. I'm very fine.
On what I've heard or listened so far this morning, I think I agree with the response that the nominee gave us to and the gender parity.
Right.
You know, that is like a wise response, and that is my position, because we shouldn't feel the position because we are saying it is 50-50 or we have to get 40. So if we have to get 40 and the 40th person doesn't qualify because we are saying it's a gender if it's a female or male, we have to make sure that position is filled. You know, at the end of the day, it's about the country, it's about Ghana. So
That's right.
Gender parity, and you are going to have 99 and 1. And that one is what is going to make the country stand on its toe and work.
Right.
Let's go by it. It shouldn't be that it is gender. I pray that it won't take long for us to, you know, revise this advice on gender parity.
Right.
Because it looks like we are giving so much focus or attention to, you know, this thing that it's not yielding any positive results. It is always female. When we are looking at the end result, that is what matters. It shouldn't be like the gender, that gender agenda, we should drop it.
Right. Thank you, Uriel. I'm grateful for your time. 055-924-2717 and 055-691-0154. That's 055-924-2717 and 055-691-0154. There's also a conversation about whether or not judges should retire at 75, not at the 70 year or at 70 years. What do you think? Good morning.
Good morning, Mr. Johnny.
Yes, sir. Jimmy Victor.
Yes, sir, boss.
Talk to me.
Mr. Johnny, you see, his lordship, Mr. Ajay or something.
Dennis Ajay. Lordship said
yes, he was asked about the gender, whatever. That's what my brother said. You see, when a person is good, let's take the person there. It doesn't matter.
That's Justice Jamefe, actually.
Whether the... Hello, Mr. Johnny?
That's Justice Jamefe you're referring to.
Yes. Yes. You see, when a person is good, let's use the person at the right position. We should just forget about gender or whatever. So see these 7 selected judges that President Mahmoud did. See, they started well. They are solid. They are doing a human job. See, let me tell you the second one. You see, we are paying our judges with our taxpayers' money. So to me, they need to declare their assets, what they have and what they are going out with. I think that is the best way because we are paying them with our taxes. Mr. Johnny, have a great day.
You too, my brother. Good morning.
Good morning, sir, Mr. Johnny.
Yes, my brother.
This is Ebenezer Donko. I'm working at Zoom now. But
okay.
What is happening now is that we are located at Gomoa Budumbura.
Are you talking about the judges or you want to talk about something else? Because we're discussing judges.
Yes, sir.
We're discussing judges now. Not about any other thing. I'm sorry about that. Sorry. Let's keep the topic. Good morning.
Good morning.
Yes, sir. Onapo. What's on your mind about the vetting? What's your pickup line?
Well, I think it gives me hope for
Sunrise on 3FM.
Listening to them, to see they are. I mean, things that are coming out from them is educated. Questions and answers. One from the lady MP about this demand.
Right.
I think it was a very good question because most of the time some of these guys in the remand, some of their cases, I think we should change. And then the answer he gave, if you change the constitution or if you change the law, we can also do what we have to do. So I think they should look at it. Some of the cases, if it has to be community service, you go and do this and then you are out. But pushing all of them to this having criminals and stuff, it's weird, frankly speaking, it is. And then with they also declaring the asset, I think yes, they have to because they are the judges. Because if they don't, how is it going to be with the lesser ones? You get it? They are high up there, so they should do that for.
Right.
I mean, the civil servant or whoever also have to do it.
Thank you, Napo. I'm grateful. Good morning.
Good morning, Mr. Johnny.
Yes, madam. What's your name, please?
My name is Akweli.
Akweli, okay. Calling us from?
From Sapema.
Okay, talk to me, Akweli.
Me, dear, me person mechanic say, Obisa no say, Obanya position, Oban point, but Nipa non qualifier, on to me,
okay, Sana Judge Nekai.
Yes, this is Nipa non qualify, and Sana obey to me. I want to say, Ma, Brema, na Obano qualified, dear. Fine. Obenya position, but Obano qualifier, on to me, not position.
That's right. Medasipa.
And Mr. Johnny.
Yes.
Open auto, ya calling letter, get no nake.
Letter ko, how many letter ko? Okay.
Okay. Me no investigate no ko ba wana proper auditors na ba fi na kanya habo.
Okay, I'll check. There are a couple of letters, so I'll check. I'll look through. Thank you very much. Okay, you are now 055-924-2717 and 055-691-0154. That's 055-924-2717 and 055-691-0154. Let me know what your own thoughts are about the vetting of the Supreme Court judges from yesterday, and it will be interesting to know what the as they say, ordinary Ghanaian or average man thinks of this. Good morning.
Good morning, Mr. Johnny.
Yes, sir.
From Amasama.
Good to hear from you. Yes, talk to me, my brother.
Okay, for me, the way you are handling the program is what I'm enjoying.
Thank you.
It's like you speak the vulnerable mind. You stand there for the voiceless. That is my impression.
Thank you very much.
So you continue to be speaking for us, and we are behind you.
I'm grateful.
Thank you.
Thank you very much, SK. Thank you so much. Good morning.
Hello.
Yes, sir.
Yeah, Johnny, good morning.
Morning, sir.
How are you?
I'm greater than Accra, boss.
Hey, you are the great man from you.
We are learning, small.
Johnny, about the judges vetting.
Yes, sir.
Everything is going well. Opinion marking is proving too supreme over the whole vetting. I mean, I don't like the way his posture goes, and they all the time be asking unnecessary questions. Take more time from the people. It's not good. They should call him to order. That guy is becoming a nuisance.
Oh, take your time. Take your time.
Yeah. We have to be honest and tell people the truth in their face so that they know that they are saving the citizen, not for their personal property. Okay?
Okay, I hear you. I hear you.
Okay, thank you.
Thank you. Good morning.
Good morning.
Yes, sir.
This is Sasha.
Talk to me.
It's been a while that I contested because of peace in the country.
Say again.
But it looks like that.
I couldn't hear that, the first thing you said.
I said it's been a while that I put on the show.
That's right.
This is your friend Lad.
I remember you.
Good. Do you know the reason why?
No, tell me.
Peace has been proceeding in the country.
I see. Okay.
When you have money or you don't have peace, there is a problem.
Okay.
So there is internal bleeding that is happening in the NPP party.
Oh no, let's not discuss internal politics. Let's talk about the judges.
I'm talking about the judges. Based on the questions that anyone is asking. He asks the question from him. If there is judges that have been nominated, why should you go ahead and ask the question about something? You give me where I'm coming from.
I get you.
Good. So internal bleeding is happening. Have a nice day.
Okay, have a nice day too. Final caller. Good morning. How you doing?
Hello.
Yes, sir.
Good morning.
Good morning, boss. How are you, sir?
I'm doing well.
Great. Your name and location, please.
My name is Kojo.
Kojo?
From Kufuria.
Okay. Could you talk to me?
Yes, I'm interested in the issue of the judges declaring the assets.
Right.
The issue is, when you read the Constitution, the declaration of the assets talks about public officers, yeah. And judiciary and all other components of the public institutions are all public service institutions. So the judiciary must submit to the declaration of the assets.
Right. So you subscribe to that view?
Yes.
Okay.
Because the chief justice is a public servant. Yes. Emphasizing that position as a chief justice, but he's a public servant.
Okay. Thank you very much for your view. I'm grateful. Okay. And maybe just let me sneak this one in. Okay, we lost that one. I'm sorry about that. We can't take any more calls then. We have to quickly go for a break. When we return from the break, we'll have a conversation. Stay with us here on Sunrise on 3FM 92.7. It's 20 minutes after 9 on your favorite morning show. See you shortly.